A previously undisclosed phone call involving former President Donald Trump has come to light through leaked documents and witness testimony, raising new questions in Congress about record keeping, oversight, and disclosure during a sensitive period of his presidency. According to multiple media reports, the call took place while Mr. Trump was already under investigation for other matters. The communication was not included in official call logs and involved a foreign leader, according to sources familiar with the documents reviewed by investigators. The existence of the call became known after a whistleblower within the intelligence community provided information to congressional investigators. That disclosure led to a document review which, according to reporting, confirmed that the call occurred and revealed limited details about its timing and nature. No complete transcript has been released publicly. Lawmakers from both major political parties have since requested further information. Members of the House Oversight Committee and the Senate Intelligence Committee have asked the Department of Justice and the intelligence community to provide any transcripts or summaries of the call, identify who participated or was aware of it, and explain why it was not recorded in official systems. At this stage, key facts remain unverified. The full content of the conversation has not been confirmed, and there has been no official determination regarding its legal significance. According to court filings and established oversight procedures, unrecorded communications involving foreign leaders can raise institutional concerns when they occur outside normal documentation practices. Legal analysts note that investigators typically examine whether omissions from official records were procedural errors or deliberate actions. Constitutional scholars also point out that Congress has broad authority to seek information related to executive branch record keeping, particularly when national security or foreign relations are involved. The Department of Justice has not publicly commented on whether the call is under active review. Mr. Trump has not released a statement addressing the reports or the congressional request as of this recording. The situation may prompt further inquiries as lawmakers assess whether additional documentation exists and whether existing oversight mechanisms were followed. Any legal or procedural consequences, according to analysts, would depend on verified evidence and formal investigative findings. Records from Mr. Trump's presidency show that concerns about undocumented or poorly documented communications arose early in his time in office. According to publicly reported accounts, there were instances in which notes from interpreter-led meetings with foreign leaders were not retained, and occasions when calls with foreign officials were not fully logged or formally memorialized. Media reporting has also documented the use of personal devices or non-standard communication channels by senior officials during that period, raising record-keeping and security questions. According to historians of the presidency and records management experts, federal law and established White House protocols are designed to ensure that official communications, particularly those involving foreign governments, are preserved for oversight, national security, and historical purposes. When communications fall outside those systems, analysts say it becomes more difficult for investigators and oversight bodies to reconstruct events accurately. Legal scholars note that avoiding written records can complicate later reviews because investigators often rely on contemporaneous documentation alongside witness testimony. At the same time, they emphasize that motives and intent must be established through verified evidence, not assumptions, and that the absence of records alone does not determine whether misconduct occurred. What distinguishes the newly reported call, according to initial reporting, is its timing. Sources cited by multiple outlets say the communication occurred in late 2020 or early 2021, a period when Mr. Trump faced active or anticipated investigations and when presidential record preservation requirements were clearly in effect. Court filings and oversight guidance indicate that these obligations apply regardless of political circumstances. According to individuals briefed on the whistleblower disclosure, the call was placed using a private line rather than official White House systems. The communication was not entered into standard presidential call logs, and only a limited number of officials were aware of it. Those accounts state that no formal written summary was prepared at the time. Experts in executive branch procedures say such departures from established protocols are unusual, particularly for communications with foreign leaders, because those protocols exist to ensure accountability, continuity, and national security review. Whether those procedures were bypassed intentionally and for what reason remains an open question for investigators. The identity of the foreign leader involved has not been officially confirmed. Media reports note that investigators are treating that detail as significant because the applicable legal and oversight considerations can vary depending on the country involved and the context of the discussion. No authoritative confirmation has been provided by the Department of Justice or the intelligence community. Sources familiar with portions of the reporting say the conversation touched on matters relevant to ongoing political and legal issues at the time. However, no complete transcript or verified summary has been released, and the full scope of the discussion has not been publicly established. As with other aspects of this matter, any assessment of legal significance, according to constitutional scholars, will depend on corroborated evidence, witness testimony, and formal investigative findings rather than preliminary reports or speculation. According to initial reporting, sources familiar with the matter say the call included discussion of Mr. Trump's efforts to challenge the results of the 2020 presidential election. Those sources indicate that he raised the issue of foreign government support, though the precise form of any request has not been publicly confirmed. No official record has been released showing what, if anything, was asked for or offered during the conversation. Legal analysts note that any involvement by a foreign government in U.S. electoral matters is treated with particular seriousness under federal law. At the same time, they emphasize that assessing legal significance depends on verified evidence of specific actions or requests, not on unconfirmed descriptions of intent. Sources also indicate that Mr. Trump discussed concerns about potential investigations he might face after leaving office. According to reporting, the nature of those discussions remains unclear. There has been no public confirmation that he sought specific commitments, assistance, or assurances from the foreign government involved. Legal scholars say that discussions about future legal exposure are not uncommon for political leaders, but any attempt to interfere with U.S. law enforcement processes would raise distinct legal and oversight questions. Reporting further suggests that classified or sensitive information may have been discussed during the call. According to individuals briefed on parts of the whistleblower complaint, the information related to foreign policy or intelligence matters. No official determination has been made regarding whether any information shared exceeded authorized boundaries. Constitutional experts point out that presidents have broad authority over classification decisions, though the context and purpose of disclosures are relevant factors in oversight reviews. The existence of the call was disclosed through a whistleblower complaint filed by a career intelligence professional, according to published accounts. The whistleblower is described as having indirect knowledge of the communication through their official duties and raised concerns through established internal channels. Reports state that the complaint was reviewed by the intelligence community's Inspector General, who determined it met the threshold for further review and notification to Congress under whistleblower protection laws. Oversight experts note that this procedural path is significant because it reflects the use of formal reporting mechanisms rather than unauthorized disclosure. The Inspector General's role is limited to assessing credibility and urgency, not determining criminal liability. Congressional response has been prompt. Members of the House Oversight Committee and the Senate Intelligence Committee have requested documents and briefings related to the call. The House Oversight Committee has sought records from the National Archives, the intelligence community, and the Department of Justice. The Senate Intelligence Committee has announced plans for closed briefings to review classified information connected to the matter. Lawmakers from both parties have publicly stated that they are seeking clarity on why the call was not documented through standard procedures and what oversight safeguards were in place at the time. Some members who have previously supported Mr. Trump have also called for transparency regarding the handling of presidential communications with foreign leaders. At this stage, investigators have not released findings and no conclusions have been announced regarding legal or procedural violations. According to constitutional scholars, any determinations will depend on documentary evidence, sworn testimony, and formal investigative outcomes. As additional details have emerged, the initially bipartisan congressional response has begun to diverge. Some lawmakers aligned with Mr. Trump have questioned the whistleblower complaint, arguing that presidents have broad authority to conduct foreign policy and communicate with foreign leaders. These members have focused their criticism on the disclosure process itself, characterizing it as improper rather than addressing the substance of the reported communication. Mr. Trump responded publicly to the reporting through a post on his social media platform. In that statement, he did not directly deny that the call occurred. Instead, he criticized the disclosure as an unlawful leak and asserted that presidential communications with foreign leaders fall within executive authority and may be protected by executive privilege. He described the whistleblower complaint as politically motivated and did not provide details about the contents of the call or why it was not recorded through standard procedures. Legal scholars note that claims of executive authority and privilege are frequently raised in disputes between the executive branch and Congress, but they do not automatically resolve questions about record preservation or oversight obligations. Whether executive privilege applies depends on specific circumstances and is often subject to judicial review. Investigators are expected to focus on establishing verifiable facts surrounding the call. According to former federal prosecutors and oversight experts, this typically includes determining whether any recordings, transcripts, or summaries exist, either within U.S. government systems or through intelligence collection involving foreign governments. They also note that investigators generally seek testimony from individuals who arranged, participated in, or were aware of such communications. Any legal assessment, analysts emphasize, depends on the confirmed content of the conversation and the context in which it occurred. If a communication involved requests or actions related to U.S. elections, law enforcement officials would examine whether applicable federal statutes were implicated. Similarly, if sensitive or classified information was discussed, investigators would assess whether established authorities and procedures were followed. At this stage, no official findings have been released. Beyond the substance of the call, investigators are also reviewing how it was handled administratively. Federal law includes requirements related to the preservation of presidential records, and obstruction statutes address the concealment or destruction of records with intent to impede oversight or investigations. Whether those provisions apply here has not been determined and would depend on evidence of intent and conduct according to legal experts. The timing of the disclosure has also drawn attention, as Mr. Trump currently faces multiple criminal proceedings and is actively campaigning. Analysts caution, however, that political context does not determine legal outcomes and that investigative decisions are based on evidence and statutory standards. Congressional committees have indicated that their review will continue. Lawmakers have signaled plans to seek documents, conduct interviews, and receive classified briefings to better understand the circumstances of the call, the record-keeping decisions involved, and any broader implications for executive branch oversight. National security specialists say the case has renewed discussion about existing protocols governing presidential communications with foreign governments. Those procedures are designed to ensure continuity, accountability, and protection of sensitive information. Any policy changes or reforms, they note, would be considered only after the relevant facts are established through formal review. Investigators are expected to face legal and procedural challenges as they examine the reported call, including claims of executive privilege and the classified nature of certain information. Legal experts note, however, that whistleblower protection laws and Congress's constitutional oversight authority provide mechanisms for pursuing inquiries even when a former president resists disclosure. The disclosure has also prompted questions about whether other communications may exist that were not recorded through standard channels. Oversight specialists say that when an undocumented communication is identified, investigators often expand their review to determine whether it reflects an isolated incident or part of a broader pattern. That process can include wider document requests, witness interviews, and examination of intelligence reporting related to foreign contacts. According to former prosecutors, the scope of legal exposure in such cases can extend beyond the underlying conduct being examined. Federal law makes it a crime to knowingly provide false statements to investigators, to obstruct an inquiry, or to destroy relevant records once an investigation is underway. Any assessment of these issues, analysts emphasize, depends on verified evidence and established intent, not on preliminary reporting. At this stage, confirmed facts include the filing of a whistleblower complaint, the Inspector General's decision to notify Congress, and ongoing congressional requests for information. Reports describing the content of the call, the motivations behind it, and its legal significance remain unverified publicly, as no transcript or official summary has been released. Members of Congress from both parties have stated that they are seeking clarity on what was discussed, why standard record-keeping procedures were not followed, and whether existing laws or protocols were implicated. Mr. Trump has responded by criticizing the disclosure process and asserting broad presidential authority without addressing specific details of the reported communication. Congressional committees and oversight bodies have indicated that their review will continue through document requests, witness testimony, and classified briefings. Any determinations regarding legal or procedural violations, according to constitutional scholars, would come only after formal investigative findings and, if applicable, judicial review. As this process moves forward, analysts note that the outcome will depend on corroborated evidence, statutory interpretation, and established investigative standards rather than political rhetoric or speculation.